Hi, this is Jonathan Ginsberg. I'd like to talk to you today about the role of the vocational witness in a Social Security disability hearing. When you go to the hearing, you will find when you walk in the hearing room that there will be people there you don't know. Obviously, the judge you've probably never met before, the judge's assistant, and that's the person that operates the recording equipment because these hearings are recorded. That's a person that you probably have never met before other than in the waiting room. And there'll be a third person in there called a vocational witness. And this is a witness who will actually testify at your hearing. And you may be thinking, well, I've never met this person. How can he or she testify at my hearing? And the answer to that is that a vocational witness is used by most judges to help better understand the work implications of your claimed disability. And remember, disability under Social Security is about your capacity to work. So the judge really uses the vocational witness to help translate, if you will, the medical issues in your case into specific work limitations and to understand what the implication of those limitations can be. So the vocational witness will be used normally at the end of a hearing. After you've given testimony, the judge will turn to the vocational witness and say, Mr. Vocational Witness, can you please describe the claimant, and of course you're the claimant, describe the claimant's past work using something called the Dictionary of Occupational Titles. And the Dictionary of Occupational Titles, which is sometimes referred to as the DOT, represents a list of every job that exists in the national economy, and is broken down based on exertional level, meaning is it sit down, light, medium, or heavy, and skilled level, is it unskilled, semi-skilled, and skilled. And each of these definitions has a specific utility in Social Security. So for our purposes, a sedentary or sit-down job means that you'd be sitting at least 6 out of 8 hours in the day with incidental standing, and unskilled job would be something you could do walking in off the street. So by definition, the easiest job that exists in the economy would be a sedentary, unskilled job, and even more than sedentary, a sedentary job with a sit-stand option so that you could do the job sitting, or if you had to stand up and move around a little bit, you could do it there as well. So first the judge will ask the vocational witness to describe your past work. Are there skills involved in it? What was the exertional level? Because one of the things the judge has to conclude is that you cannot do your past work. And let's assume that that's the case. So then the judge will continue to ask the vocational witness about whether you can do any other kind of job. And the way the judge does this is he will pose hypothetical questions to the vocational witness. So again, after testimony, after we've brought out all the limitations that we believe that you display, the judge will say to the vocational witness, Mr. Vocational Witness, assume an individual with the same age, education, work experience as our claimant. Assume further, I find that he is limited to light work, and again, light work has a definition, with the following limitations on that light work. This individual cannot climb ladders, ropes, and scaffolds. This individual can crouch occasionally, bend at the waist, but never kneel. This individual cannot work around hazardous equipment or in unprotected heights, and so forth. And so the judge will go through a variety of limitations, then will say, based on these limitations, can this individual return to past work or any other kind of work? And obviously the more limitations we have, the less likely the vocational witness will say, yes, there are jobs that I can identify. And so if the vocational witness does come up with jobs, that means that you would not be disabled. Now, realize that judges will ask these questions. Sometimes they start by asking questions where there are mild limitations. Then they keep asking questions to come up with more limited limitations so that you cannot work. So some of the questions may result with, yes, there are jobs that this person can do, and then question 3 or 4 may be, the answer would be, there are no jobs this person can do. So obviously we don't know necessarily what the judge is thinking, but what he is going to be trying to do is draw that line. Where do I find this individual would be disabled? For example, if the limitation has to do with unexcused absences because of, let's say, bathroom problems, bowel or bladder problems, then one unexcused absence every 3 days is probably not going to be disabling. but 3 unexcused absences a day would be disabling. So again, we're trying to move the meter so that the judge includes a lot of significant limitations in his hypothetical to the vocational witness, so that that will ultimately be his conclusion. And part of what my job to do with your case is, in preparation, is we identify those limitations and try to put specific time, distance, and so forth, so that we're not talking about can't sit for very long. We're saying we can sit for 6 to 7 minutes, then need to take a 4 to 5 minute break walking around. That's a whole lot different than saying I can't sit for very long. So the vocational witness is there to help the judge understand the work activity limitations that arise from your particular medical problems. And what we're trying to do during the hearing is to seed the record, plant in the record a number of very, very significant limitations, so that the questions the judge asks include these very, very high level limitations, so that the answer the vocational witness gives at the end of the hearing is, I can't think of any jobs this person can do. If we get that result, that there are no jobs you could do, and that's the question that the judge uses as his conclusion about your capacity, then we win. So that's what the vocational witness is there to do, and that's a little bit about how I try to proceed during my hearing, so that you're giving the correct information and giving the right kind of testimony. And if all goes well, we'll get a favorable decision. Hope this has been helpful. Again, I'm Jonathan Ginsberg, and any questions you have for me, please let me know. Thanks a lot.